So the Supreme Court has relisted the legal challenges which sought to overturn statewide prohibitions on so-called assault weapons, and then the magazine restrictions as well, and this would be a massive decision that would transform the landscape of rifle bans and magazine bans nationwide. So we need to discuss some of the fascinating territory that these cases are now in because of all these relists. In this video, we're going to be discussing some very significant developments in a couple cases which challenge various state prohibitions on so-called assault weapons and then magazine restrictions as well. These critical cases we've covered in the past are Snope versus Brown, and then also the Ocean State tactical case. We've been monitoring these two cases because the Supreme Court has now relisted the cases 15 times for conference. And most recently, they had a relist after a conference, and the recent relist is for May 22nd. That pushes the number up to a point where something is likely happening, and something more is probably occurring than just a simple dissent in denial of these cases. This high number of relists plus the court's term concluding really soon, late June, early July, means that these cases are more compelling than ever, and probably something else is happening more than just a denial. I think we're now beyond the point of just simply saying the Supreme Court is going to postpone the decision and then disappoint us. Just deny these cases. Obviously, that's still an option, but I think all indicators and all signs point to maybe something else occurring. Now, for those not familiar, the Snope case is kind of the largest case out of the two because it addresses a state's prohibition on so-called assault weapons, which has previously been GVR'd by the Supreme Court after Bruen. This case involves a state of Maryland, prohibition, and the state law defining certain firearms as so-called assault weapons and therefore limiting their access to the residents. This rifle prohibition was challenged in a Maryland federal district court. However, the case was then dismissed by the lower court because there was already a case on the books and there was some precedent there in Maryland where a prior court had already determined that this did not violate the Second Amendment. Now, that prior case was called Colby, and it was decided on previously by the Fourth Circuit on panel. This case, Snope acknowledged that Colby was the controlling precedent in the Fourth Circuit, but they said it was wrong and should be overturned. Now, that dismissal of the case was then appealed to the Fourth Circuit, and the Fourth Circuit once again sustained the dismissal. Now then, this case eventually made its way to the Supreme Court back in 2022, and it was seeking Supreme Court review from them back, in 2022. But that was prior to Bruen. Now, ultimately, the Supreme Court issued the landmark ruling in Bruen, and this case, Snope, was then GVR'd, meaning that it was granted, vacated, and remanded back down to the Fourth Circuit for a new decision in light of what the court stated in Bruen. The Fourth Circuit on panel eventually issued their ruling upholding the Maryland rifle prohibition as constitutional. Now, the Snope case was originally scheduled for Supreme Court conference back on December 13th of last year, but then the court issued a preemptive reschedule of this case. It was then relisted multiple times, and now it's been relisted 15 times. And now, most recently, the conference has been scheduled for May 22nd. Now, the other case that has followed all along with the Snope case is the Ocean State tactical case. And in that case, the plaintiffs challenged the state's magazine prohibition and a lower court's denial of a preliminary injunction. Now, unlike Snope, the Ocean State tactical case is still in an interlocutory posture, meaning that it addresses a preliminary injunction and a denial of that preliminary injunction. But again, it addresses a state's magazine prohibition. Now, you may be wondering what is happening with all of these relists, and why has the Supreme Court relisted both of these cases 15 times, and maybe why is that so significant? Well, that's because all Supreme Court analytics on prior cases show that a case has a higher probability of being granted review by the Supreme Court if it's relisted only one time, but also the data reveals that multiple relists like what's happening here in the Snope and Ocean State tactical case often indicates that the case is going to be denied review. However, there is also some interesting information and data that reveals that there's kind of a breaking point where a high number of relists no longer indicates that there is going to be a denial, but instead maybe there is increased interest in a case. A high number of relists, like the 15 times in these two cases, sometimes happens in very high-profile and controversial cases, and often can indicate that the Supreme Court is going to grant review. For example, the Dobbs abortion case was relisted 12 times before we got any official notice on the docket that the Supreme Court had granted review to that case. Also, the Masterpiece Cake Shop case was relisted 14 times before it was officially granted review on the docket at the very end of the October 2016 term. A high number of relists can begin to suggest two things beyond just a simple denial and a dissent. It can mean that, one, that the justices voted to grant the petition and resolve the case summarily, maybe through something like a per curiam opinion. So the petition gets relisted on the docket until the unsigned majority opinion finally actually is filed and is made known to everybody. The second option is that the justices voted to grant the petition and are deliberately kind of delaying, and they're making the decision to not make that public, perhaps to put the case out until the next term, and they're just kind of waiting to announce and disappear at the very end of their term and kind of let everybody panic during the recess so they don't really have to handle it. You know, kind of at the last minute of a term they say, "Yep, we grant a review to this case." Everybody panics, but the Supreme Court doesn't really care because they're on recess. So where does all this information and the 15 relists of these two cases really place us? Well, there are now 3 real possibilities that could play out in these two cases. First, the Supreme Court could simply be stalling, and all that could happen is a simple denial of the cases. However, I'm beginning to think that that is less probable in this situation when you look at the fact that the Supreme Court has denied review outright to other cases that went to the same conference with Snope, like the Gray versus Jennings case, which addressed magazine bans on an interlocutory review, and the anti-carry case. It signals that they're just simply not going to deny review to these cases like they did those others, because if they were, they would have just denied review after the initial conferences. Now, the other two possibilities I think are more probable in these cases, especially now because of the 15-plus relists. The higher number of relists start to suggest that maybe something like a per curiam opinion, or that the court has agreed to take these cases but is simply just trying to time it and grant review at the very last minute. You know, maybe at a cleanup conference. The per curiam option would be intriguing because the high number of relists would simply mean that they are, kind of using them as a placeholder on the docket before they officially file and, write out that opinion and announce it to everyone. For those not familiar, a per curiam opinion is an opinion written by and in the name of the court. It's not, identifying a simple single author on the opinion. It's just kind of in the name of the court, and you just need a majority, in that to write the per curiam opinion. And they could just simply using all these relists as a placeholder until they reveal the opinion. The other possibility is that they could be using the relist once again as a placeholder, but for a different reason. It could be that they've already agreed to grant review to this case, or at least there was a majority in the court who has decided to grant review to this case. But they just haven't announced that yet. They're going to wait until the end of this term, announce it, go on recess, and kind of let everybody else handle it, and they don't really have to deal with all the backlash from anti-gun groups because they're going to be on their little summer break, and they don't, have to hear from it. And they do that quite often, especially in high-profile cases. Again, like I mentioned, they did that, I believe, in Dobbs, and they also did that in the Masterpiece Cake Shop case and a lot of other cases as well. There's a track record in the Supreme Court of them doing this type of thing, relisting multiple times and at the end of the term, granting review and then going on their recess. I'm becoming more optimistic that something positive could be happening, but there's also the possibility that the court will still crush all of our hopes and just simply deny review to these cases. However, that would be very unusual and potentially a really cruel joke from the Supreme Court if they've relisted these 15 times, and then at the end of this term, we get a notice on the order saying, well, we just simply denied review and there's no dissent or anything like that. That would be very strange, and I wouldn't really comprehend why they decided to relist these 15-plus times. So these cases are now entering a very critical phase. All eyes will be on the Supreme Court as they advance towards the end of this term. So as we get more information as this develops, I will update you guys. But as always, thank you all for watching. Don't forget to like, comment, and subscribe.